Washington State Court of Appeals is now reconvened. Our third case this morning is a motion for discretionary review, case number 61227-5, State v. Cody Curry.
Thank you, and good morning, everyone. Because we're conducting this hearing on TBW and Zoom, I just want to make sure that the attorneys can both hear me. If you just give me a thumbs up. And thank you. And so, counsel for petitioner, it looks like you're reserving 5 minutes for rebuttal, and you can proceed when you're ready.
Thank you, Your Honor. Good morning. And before I start, I'd like to make a quick note of clarification. When this case was heard in the trial court, we were under RCW 1077-086. And then at the time I wrote my brief, it was 7010, and in their infinite wisdom, either the legislature or the code reviser has again changed the number of the section to 645, which I believe the respondent has correctly noted in their brief. But just for clarification, and
before
none of the contents have changed.
Sorry, thank you for noting that, counsel. We had noted that as well. But before we continue, if you could just introduce yourself for the record as well.
Oh, yes, and I'm Randall Sutton on behalf of the state. Sorry.
Thank you.
So I think this is a fairly straightforward statutory construction case. Basically, 645 has three sections that are relevant for our current purposes. I'll start with 6, paragraph 6, which says that basically if the court finds that the defendant is incompetent after the first review period, it may order further competency restoration proceedings, except if it's the defendant is ineligible under subsection 4. And I'm going to read subsection 4 because that's really the heart of this issue. And the trial court basically disregarded it because he didn't feel that it made sense. But so subsection 4 says, when any defendant whose highest charge is a Class C felony, which is what we have here, is admitted for inpatient competency restoration with an accompanying order for involuntary medication under 1077-665, and the defendant is found not competent to stand trial following the period of competency restoration, the court shall dismiss the charges pursuant to subsection 7. Well, here, the defendant was not subject to an involuntary medication order, and the trial court, for whatever reason, felt that that was an irrational distinction. But basic statutory construction 101 is that if the provision is clear on its face, we don't go to interpretation and looking at what the legislature intended and that sort of thing. And I would submit that there is nothing remotely unclear about the language of the statute. It's very clear. And the arguments that Mr.
So there's a statutory construction rule that's basically saying that the court shouldn't interpret a statute in order to reach an absurd result, right? It sounds like what you're saying here is we don't go to that doctrine because even if the law is confusing or even if it's unfair, it's clearly written. Is that right?
Yeah, that's exactly right. And I would add as an aside here that it would be perfectly reasonable for the legislature to conclude that in a case where we're forcing medication on someone against their will, we're not going to extend that period if it's unsuccessful. And that seems to me like a reasonable choice for the legislature to have made. But again, we don't even get there because there's no ambiguity in the language of the statute. And that's pretty much everything that this case is about. And then we get to subsection 7, which says that the court shall not dismiss the charges if the defendant is eligible for a third competency or second or third competency restoration under subsection 6. And 6 only excludes you if you're ineligible under 4.
So I understand the state's statutory interpretation position. Can you explain to me a little bit about the effect prong for B1? Given that this was a dismissal without prejudice, can't the state simply refile? And doesn't that solve the issue? Does this really have to go to a full appeal?
Well, I mean, I think the state can't or can't ethically refile unless we have reason to believe that the defendant's going to be competent to proceed. Otherwise, we're back in the same place and presumably in front of the same judge, and who is going to say, well, I've already ruled that he's not eligible for further competency restoration under subsection 4. And I would suggest that also under 3, which doesn't have that impact requirement, that the court has so far departed from the acceptable and usual course of judicial proceedings, that the judge disregarded the plain language of the statute because he found it didn't make sense. But I would suggest when you look at it, the language is very clear, and we don't get to statutory construction at all. So, yes. And also under subsection B, we've significantly altered the status quo. There was a pending criminal charge, now there's not. And I think this is probable error because the statutory language is quite clear. And I see I'm just about out of time, unless the court has another question.
No, you can reserve the remaining time if you'd like to.
Thank you.
And counsel for respondent will reset the clock here for you and just take a second. And then you can proceed when you're ready.
Yes, Your Honor. Natalie Feeney on behalf of Cody Curry, the respondent. I mean, I'll rest primarily on my briefing here, but I guess I do disagree with the idea that if something literally is unambiguous on its face, it cannot be ambiguous still on its face within the realm of the type of law we're talking about. So I do go into my briefing in this, but I would argue that the statute, the subsection, specifically subsection 4, is ambiguous both as applied and on its face. As applied because it would result in absurd results, and I believe that the trial court judge kind of latched onto that immediately. But on its face as well, specifically because under local practice, at least, I would say it would be extremely rare for anyone to get sent to that initial restoration period with an accompanying order of involuntary medication. That would require the cell hearing to have been requested and to have happened prior to even the initial competency restoration period of 45 days. And I can only think of a very rare situation where that would even happen. Typically, a defendant would have to be consistently refusing their medication at Western State Hospital for the requirements for cell to even be triggered for the state to order a restoration or a cell hearing during that restoration period. So I think the plain language of the with the accompanying order part is the ambiguous part, because I think that would be rare for that to happen. And I can only picture that happening in a situation where someone is sent back and forth from Western State multiple times during the pendency of a case, which wasn't the case here. Specifically as well, I think it is important to address the statutory construction if something is going to be ambiguous as applied. And here, it is ambiguous as applied because it would create an absurd result. And I think that is important to note. The role of the court is to interpret statutes, and they're supposed to interpret statutes in a way that avoids absurd results. As I go into in my briefing, this creates absurd results from, it would create the absurd result from both prosecution and defense of it puts defense in a position where they either have to check the box to, you know, require involuntary medication from the beginning to hopefully get a dismissal for their client, which is a good result for their client. Or it means that defense, if their client is charged with one of these, you know, nonviolent Class C felonies that are carved out here, we should be advising our clients to not take their medication in the hopes that the state requests a cell hearing. And then at that cell hearing, I guess defense would have, like, it creates the incentive in defense to not win the cell hearing so that their client is forcibly medicated, again, to potentially trigger grounds for dismissal down the road for their client, which would be a favorable result for their client. More troubling, I think, is the incentive it creates in the state to just not request the cell hearing. You know, under practice, it's the state that requests the cell hearing because it's the state that is the one arguing that they have the governmental interest in, you know, a client being or a defendant being forcibly medicated. The existence of subsection 4 pretty much incentivizes the state to, in this carve out of cases, never request a cell hearing, especially during that initial restoration period, or maybe otherwise they would, you know, a week or two into the restoration period if someone's refusing their medication, just so that they can trigger an additional bite at the apple and just so that they can essentially mandate all defendants get an additional 90 days at Western State Hospital, which I think is troubling from a defense perspective, that the state would have that power to just simply not request a cell hearing at all, even if it's something that would be requested.
So, counsel, I understand your point on that statutory interpretation issue. Can you address briefly the argument on the effects prong that here, although it's a dismissal without prejudice, the state cannot ethically refile because it would just be back in the same place, same judge, get the same result? Is that, would you agree with that, at least part of the state's argument? I'm just trying to make sure I distinguish the things you agree with versus disagree with.
I guess theoretically, yes. I mean, I do note that I believe even the trial court judge noted that because this was without prejudice, I think that did lend itself to the trial court's decision. I think it would still be important to get the clarity, I guess, of the interpretation here, just because I guess I would agree that you're kind of back in the same boat, and then you're back in the same boat of whether or not you're questioning, well, is it an initial restoration period of 45 days then that gets triggered all over again, and then, you know, we're fighting the same battle in 45 days? Or is it, you know, are we back fighting the same battle about the 90-day restoration period immediately? So I guess I would argue that theoretically the state, you know, could refile, but I think agree with the state that ultimately this would be in the same position, especially if we're arguing about the amount of time that Mr. Curry would have to go back to restoration for from the very beginning of the case.
Thank you. And so if this court granted review, is there any immediate prejudice to your client other than obviously the future repercussions of that? But yeah, I guess my question is, what are the repercussions to your client if this court did grant review?
I guess, I mean, the repercussions would be that my client is being prosecuted for something that, you know, the doctors have found that he doesn't have the competency to understand or assist in his defense on.
But unlike a case where a trial judge applied the statute in the opposite way, in the way the state would prefer, in this case, your client isn't currently undergoing any kind of treatment, involuntary or otherwise, and is not currently in custody based on this set of circumstances. Is that right?
Yes, Your Honor.
Okay, thank you. And if you had anything further, you still got a couple minutes remaining.
I mean, I did just want to add that I do think subsection 4 was properly addressed prior to subsection 6 being properly addressed, specifically because subsection 6 of the statute does say no extension shall be ordered for a second or third competency restoration period if the defendant is ineligible under subsection 4. So I think, especially given the charges that Mr. Curry is facing that fall under that carve out under subsection 4, it was necessary to address subsection 4 before getting to subsection 6. And I think the very existence of that subsection 6 still incentivizes all of the things that I've already indicated.
So does subsection 4 apply to a voluntary medication plan?
I guess that's the question. I think the trial court judge, determined that just given kind of the ambiguity of the fact that people are not sent to Western State for an initial restoration period with that accompanying order for involuntary medication, that a fair and reasonable reading of the statute would be to effectuate what it seems to suggest is, or at least what one reading of it would be, that if someone's medicated for 45 days at Western State with one of these specific charges and they're still not restored, the court shall dismiss. I believe in this case, the judge used his discretion to effectuate what is a reasonable interpretation of a statute that is both ambiguous on its face and as applied, even if the literal definitions of the words included in the statute aren't ambiguous. I think it can still be found that it is ambiguous on its face and as applied. And I think the judge here used his discretion in a reasonable way, did not abuse his discretion, did not commit error. So I guess I would ask that the court deny discretionary review on this matter.
All right, thank you, counsel. Counsel for petitioner, you've got a few minutes remaining and you can proceed when you're ready.
I don't have much additional to say other than to point out that everything counsel is arguing is policy questions. And the time for that argument was when the legislature enacted the statute. And again, I don't think it's an absurd result. It's a forced medication is, I think, well recognized as a significant curtailment of bodily autonomy, etc. And I think it's entirely reasonable that the legislature said if we're going to be imposed